Who are the people in the phrase, the right of the people to keep and bear arms shall not be infringed? Do the people include me, you? Do you have to be in a militia? Does that include that jerk who flips you off in traffic? That's what we're talking about in today's case, which came out of the Ninth Circuit Court of Appeals, U.S. versus Duarte, aka Shorty. That's the name listed on the case, and you can find that case linked in the description box below, because the Ninth Circuit Court of Appeals just said that the felon in possession of firearms statute may not apply to non-violent felons. Guys, let's get into it. Okay, so even if you're not a felon, this still applies to you. Why? Well, maybe you know someone who's a felon, but more likely, you know someone, including yourself, who might be, a person. And you might be wondering who are, quote, the people, when the framers and the founders of the Second Amendment went on to write that the people are the protected class when we're talking about folks who are protected by the Second Amendment. So the interpretation of who are the people is kind of important. And there's actually a U.S. Supreme Court case going on right now, U.S. versus Rahimi, that we've been covering extensively on this channel. But guys, in this particular case, U.S. versus Duarte, we're talking about two particular battles. First, what's the definition of the people? Second, are there historical exceptions that would allow the government to basically regulate people out from the people who are protected by the Second Amendment? So those are the two battles that we're going to be talking about here. Who are the people? Who are the folks that are protected by the Second Amendment? And then what historical laws and regulations fit within the nation's tradition that can separate out people from that? First, as always, we're going to very quickly cover the facts of this case. So this case comes from a traffic stop that took place back on March 20th of 2020. Remember those days? I do. Long story short, police officers turn on their lights to stop a car that blew a stop sign. They see what they suspect is a firearm go out the window, yada, yada, yada. Felon in possession of a firearm is basically where we're going. Mr. Duarte is indicted, winds up actually going to jury trial, loses, and gets sentenced to over 4 years in prison, appeals, and here we are. Now, just as importantly, the offenses that he's been convicted of previously to make him that felon are all non-violent in nature. So we're talking about someone who's been convicted of vandalism, a felon in possession of a firearm charge, we've got a drug charge, and then 2 convictions for eluding police. So basically a traffic stop. Now I realize that you might be thinking about something you've seen on Cops where they've got people going 150. I don't know if it was that, but I'll also tell you that many times eluding statutes have very technical definitions. So if you even accelerate your car, that might constitute a felony eluding. And I'm not saying you should do that. I'm just saying that sometimes there can be very technical definitions depending upon your state. So just keep in mind. So just who are these people that have all the rights? And again, newsflash, the U.S. Supreme Court is going to be putting a lot of language down on this. They're going to be spilling a lot of ink when they're going through this on the Rahimi case. We've analyzed that to death in other videos, so I won't repeat it here. If you want to see that, check it out. So in this case, the court starts with what the U.S. Supreme Court has already kind of laid out from the question of who are the people. In the Heller case, that's part of the holy trinity of gun cases that everyone, if you're a Second Amendment fan, you should know. Heller 2008, McDonald 2010, Bruin 2022. And if you only can remember 2, Heller and McDonald, those are like the holiest of the holy trinities, okay? Heller said that the people are the holders of the Second Amendment right, and this was the starting point for the court's textual analysis from page 581 of that decision. The court began by tracking that phrase across various provisions of the Constitution, the people. Now, much like the Second Amendment referred to the people in the context of individual rights, the First, Fourth, as well as Ninth Amendments all use that phrase as well, that in law we can call it a term of art, and the U.S. Supreme Court called it unambiguously referring to all members of the political or national community, not an unspecified subset. So it's all members of everyone in the nation, not an unspecified subset. So the people, when you see that, it applies to everyone. The Supreme Court went on to declare, quote, a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans, period, End quote. Okay, so how does the government argue against this? Well, the government argues that, quote, the people only refers to the virtuous subset of citizens. I just read you the quote. A strong presumption that the Second Amendment right is exercised individually and belongs to all Americans. All right. But they did say strong presumption, that U.S. Supreme Court. So that does kind of leave a little bit of wiggle room. Maybe the government's going for that. Guys, I'm really curious, who's watching this video? Are you watching this because you're really curious about where these legal arguments are going from the trenches? And I'm just trying to give you the broad strokes in these videos. Otherwise, they'd be 3 hours long as we go through everything. But what kind of stuff do you want to know? Do you like the more minutia? Do you like the broad strokes? Are you just a legal eagle for all this stuff? What makes you interested in this? And don't forget to hit that like button. I look forward to reading the comments. Now back to the video. So what kind of arguments did the government have? Well, they're going to point to a well-known 19th century legal commentator that odds are you haven't heard of, but most people who survived law school have, by the name of Thomas Cooley, who wrote a once popular book called Treatise on Constitutional Limitations. No doubt you've not only read this so many times that you actually have it committed to memory. So I'm just going to skip you ahead to the relevant part. No doubt you can Wikipedia it on your free time if you want to learn more. In that work, Cooley wrote that, quote, the people in the legal sense must be understood to be those who are clothed with political rights. Now, again, this is the government's argument, such as the right to elective franchise. When used in this connection, this is Cooley and this is the government, said that certain classes have been almost universally excluded from the phrase the people. So this is him arguing that the people is not universal. He points to evidence such as slaves, women, the infant, the idiot, and the lunatic, as well as the felon. You can find this from pages 36 to 37 of that same work. Now, the theory here, and I, again, cannot emphasize enough that I'm not the one putting forward these views. I'm only the one teaching history. But the theory was that those groups, quote, lacked either the intelligence or the liberty of action, or in the case of felons, quote, the virtue that was essential to the proper exercise of the elective franchise. Okay, so the reason why this is important is because the government is arguing that Cooley was a very influential writer, very, very influential writer, in fact, during the middle to later part of the 19th century. And his legal thoughts are going to be important to establish what was the common understanding and framework of the definitions of the people and so forth. So how does the court deal with this? How about by looking to another work by Cooley, so the same author, where he clarified this viewpoint later in his life. So Cooley went on to explain this in more nuance and detail when discussing the First Amendment in his 1880 work, again, another one I know you have committed to memory, General Principles of Constitutional Law. And by the way, just out of curiosity, if any of you have read that out there, or either of these, or have heard of Thomas Cooley, let me know in the description box below. I'm curious, how many people know this? And if so, how and why do you know this? So while discussing the First Amendment in that later book in 1880, he wrote in part, quote, when the term the people is made use of in constitutional law or discussions, it is often the case that those only are intended who have a share in the government through being clothed with the elective franchise. So far, we're on point to what he said earlier. However, he then says, but in all the enumerations and guarantees of rights, the whole people are intended. In this case, therefore, the right to assemble is preserved to all the people and not merely to the electors or to any other class or classes of the people. All right, so I'm going to say the important part again more slowly. For those of you who are civilian disarmament enthusiasts, you don't have to try this one again. It's been refuted. Quote, but in all the enumerations and guarantees of rights, the whole people are intended. End quote. Yes, you are anti-civil rights if you're trying to disarm folks. Plain and simple. Or, as the court summed it up when they turned the government's own thinker against them, quote, so we add Cooley to the already long list of influential writers who understood the people in the rights context to mean the whole body of citizens and the right of the people to keep and bear arms as every citizen's right. Yeah, this wasn't a situation where you had Cooley saying, no, it's only these people, and everyone else basically agreeing with him or him being the only thinker in the room, this was the only thinker the government could pick up. And it turns out he's actually against them. Oof. Now, just as a note for your Googling, this understanding of the phrase, the people, is what we call the national community understanding of the definition, the people. On to the next battle. So what about the historical analogues to shore up this felon prohibition? Because again, even if the people win the argument of who are the people, the government can still keep this exception if they show that it fits within the national framework of the tradition of regulating people and firearm laws and so forth. So to bolster this, because the burden's on the government now, the government pulls out some proposed changes to the Second Amendment that never went anywhere from the time of passing. These exceptions generally deal with the fact that the Second Amendment applies to folks who are not in an act of rebellion, or maybe to folks who are also not peaceable, which maybe is a way of saying they're a felon. So they're going to point to 3 state proposed changes to the Second Amendment at the time of the drafting. So we're at about 1790. The first one, quote, Congress shall never disarm any citizen unless such as are or have been in actual rebellion, end quote. Next one, quote, be never construed to authorize Congress to prevent the people of the United States who are peaceable citizens from keeping their own arms. And then the third one said, the people have a right to bear arms for the defense of themselves, and no law shall be passed for disarming the people or any of them unless for crimes committed or real danger of public injury from individuals, end quote. So I think the second and third ones are Massachusetts and Pennsylvania. I forget where the first one came from offhand. If you know, let me know in the comment field down below. Okay, but do 3 changes that were debated among certain states, so these were not necessarily put forward, none of them advanced. And both the Massachusetts and the Pennsylvania example were actually, when they were voted on in those states, the clear loser, the clear minority to let alone move forward to try to meet this Brune threshold, which is what the government must show that these proposed, debated, and rejected exceptions form a, quote, well-established and representative tradition of regulating firearms. They were debated and lost, and it was only 3, and they were debated and lost. Good luck with that. And by the way, just for extra credit, neither Massachusetts or Pennsylvania incorporated that proposed language for the federal Second Amendment into their own state equivalent of the Second Amendments for their state constitutions. So they aren't even representative within those states. These are the arguments that we have to deal with. Now, the arguments continue to go on to different topics that we've covered many times on this channel before, such as laws that prohibited slaves, laws that prohibited free blacks, Catholics, British loyalists from possessing firearms as somehow constituting safe and morally great ground to compare someone who had now recently been convicted of a nonviolent felony today. And again, these arguments go on and on and on. We've covered them many times before, but this video, we just lack the time to do that. So if you want to see that, you can either see the court's dissection of these arguments starting on page 37 in the link in the description box below, or you can click on one of our many videos where we've gone through this involving the history of firearm laws, as well as all these different issues when they frequently resurface. If you want to see me just do a video where all I do is reject and kind of go through these arguments, let me know in the description box below, but it's just too much to do this ad nauseum every single time. Now, I need to make this emphatically clear. If you are a felon, do not go out and possess a firearm and say, Tom Grieve on YouTube said it was okay. No. Number 1, I'm not your attorney. Number 2, that is emphatically not what I'm saying. The Ninth Circuit has said that as applied to this one individual, good to go. Not to you down the lens. Where this is relevant, however, is where this starts to form legal momentum to get these laws changed. We've seen this before. We've covered similar issues, identical issues almost, before when we're talking about felon prohibitions and the Second Amendment. We're going to have to see where the U.S. Supreme Court goes with the Rahimi case. Now, to reward those of you who made it this far, let's hit you with the quote of the day. This one comes from Marcus Cicero. Quote, the higher we are placed, the more humble we should walk. Always great to see Cicero out there. And it's always great to see you, and I look forward to seeing you again, and not only in the next video, but in the description box below. Don't forget to hit that like button if you've not already done so. Let me know you like videos like this, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.